18. We could have a short quiz. Has that ever happened? You guys ever get a spontaneous quiz in class? Do you know there? Yeah. There is a philosopher's joke about why you can't have a quiz, a surprise quiz. It involves the kind of game if you work your way backwards from the last day of class. You could not have a surprise quiz on the last day, so you eliminate that day, and then the next to last. It makes a kind of logical sense, even though it's crazy. It has its own logic. But oh, okay, when we're ready. Well, okay, guys, I think I'm ready. So I'd like to welcome you to the last lecture of the class, which will be very different from what we've done previously. I've also been asked to welcome all our viewers out in webcast land or podcast land, where they exist, and to note that this talk will be available on Stanford iTunes in a few weeks. I'm not sure exactly when. So if you want your parents to see it, or share it among friends, that'll be fine. So the title for today: "Time for a Ticklish Experiment, or Should We Celebrate the Constitution's Quarter Millennium, 250th Anniversary in 2037, when I still hope to be here at age 90, God willing." It's meant, the title, as you know, I'll remind you, comes from Madison's 49th Federalist, which we read somewhat in some detail earlier in the class. I'll say a little bit more about it as we go on. The whole idea of constitution making as being a ticklish experiment, I think, was central to Madison's thinking, and I want to use that motif this morning as we go along, and I'll start the lecture by explaining why. But as I do that, the first thing I want to do is to kind of pay a little homage to a late colleague of mine, Carl Degler, who died right after Christmas, 2 days after Christmas. Really my closest friend in the history department. I'm sure a number of the people out in webcast land will remember him as a professor. We had a little memorial service for Carl on Sunday at the faculty club, and one of the motifs that came up, I think my colleague Estelle Friedman and others mentioned the idea that Carl would tell his colleagues, as he say, here, write what you teach. And as far as this course goes, I think that's become my intention, because I now have the idea of doing at least 2 books that would be kind of constitutional histories. One I've thought of doing, I would like to call a ticklish experiment. And like this course, it would be a course that emphasizes the history of the Constitution as a set of institutions rather than the history of constitutional law as a set of decisions. So that motif that I've tried to stress throughout this course, that when we think about the Constitution, we're thinking about a set of governing arrangements. In some cases are important, but we don't really care all that much about judicial doctrine. So trying to write that kind of history, I think, would be kind of fun. And then the second thing I want to do is, and I think I may do this one first, though I need to wait at least until the 2016 election, is to do a book that I'd like to call Vices of Our Political System. And the inspiration from this would be, the document that I hope you guys remember pretty well, especially since it may or may not appear on the final exam, Madison's famous Vices of the Political System of the United States, which I think is just a wonderful document to work with as a historian, because, as I try to suggest then, remind you now, it's an example of a politician thinking in the active sense of the term, not publishing his thoughts to persuade others, but thinking analytically for purposes of trying to figure out what form an experiment in constitutional reform should take. So the idea of doing a book called Vices of, the Vices of Our Political System, at a moment in American history when it seems to me we are vexed with some quite disturbing vices in terms of how we think our political and constitutional systems are operating, I think that would be a lot of fun. For a historian, it's kind of a curious endeavor to engage in, to kind of comment on current events in that kind of way. Not exactly what historians are supposed to do, but I feel at my age and I have First Amendment rights to say pretty much whatever I think, and it might be fun to try to do that. And when I do that, one thing I want to make clear, and I couldn't resist putting this quotation up, Sai Prakash is a kind of professional colleague of mine who used to teach at the University of San Diego Law School, is now at UVA Law School. He did a review of my book some years ago, my book Original Meanings, kind of probably, I think, 1997, 98, in which at the start he says, in reality, Rakove's problems, I may have many problems, but I hadn't realized this was one of them. In reality, Rakove's problems lie with the Constitution and the very concept of law. Whether he knows it or not, Rakove did not think much of our Constitution. Nothing could be more false. I love our Constitution. It's been good to me. I've been trying to reciprocate. It was good to my grandparents. If you look at my annotated edition of the Constitution, it's dedicated to the memory of my grandparents, to whom I'm eternally grateful that they came to the United States about 110 years ago, give or take. Rather than staying in Tsarist Russia, I think that was a great step forward for our family. So I love the Constitution in lots of ways. But loving it is not the same thing as thinking uncritically about its properties. So what I want to do in the balance of time remaining to me this morning is to talk a bit about the American constitutional experiment. I'm going to try to frame this in somewhat historical terms at the outset. I want to talk at the start about what I call two Madisonian dilemmas in the exercise that I want to perform in the rest of the time remaining to me. But I want to start off on a historical note, and then I, as you can see from the outline, I have three examples of what I call here Rakovian vices. This is not based on the Rakovian Catechism, which appears in Socinian theology. We'll put that to one side. Just my own assessment of things I'd like to change about our Constitution. So let's start with this famous statement from Alexander Hamilton, which appears in the opening paragraph of The Federalist. And I'm fairly sure I quoted this earlier in the course. It's been frequently remarked that it seems to have been reserved to the people of this country. I love the frequently remarked. That implies that I think what had been a revelation in 1776, by 1787, had become something of a commonplace. Anyhow, it's been frequently remarked that it seems to have been reserved to the people of this country by their conduct and example to decide the important question, whether society's men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. So this kind of remarkable self-appraisal, which I think became very, as Hamilton implies or says, really became kind of a commonplace for the revolutionary generation, that what they were doing, the experiment in which they were engaged, was a true novelty, for which there really was no satisfactory, adequate precedent or antecedent. The whole idea that, that a society could convene under the right sets of conditions and think rationally about the form of government under which it wanted to live, rather than to be governed by accident, which I think is a code word for monarchy, because genetics always has an accidental component if you're living in a monarchical system, or force, which of course means conquest. I think that's a remarkable revelation. And Madison picks up on this a few essays later in Federalist 14, where I think he expresses his own deep confidence in the idea that constitutional deliberation is something we are capable of doing. It's not something we've just inherited. It's something that any generation, particularly that generation, was capable of doing. So if you look at this, this quotation, is it not the glory of the people of America that whilst they have paid a decent regard to the opinions of former times and other nations, they have not suffered a blind veneration for antiquity, for custom, or for names to overrule the suggestions of their own good sense, the knowledge of their own situation, and the lessons of their own experience. To this manly spirit, you have to apologize for the gender nature of the remark, but that's how they spoke in those days. To this manly spirit, posterity will be indebted for the possession and the world for the example of the numerous innovations displayed on the American theater in favor of private rights and public happiness. You guys should remember that Madison's dual criteria of the public good consists of protecting rights and pursuing public happiness, or the public good. So in a sense, this is Madison endorsing Hamilton's position. It's essentially the same point. We don't need to allow veneration for the past, kind of slavish a sense of deference to blind us to the lessons we can draw through the own force of our reasoning. So this is Madison, I think, speaking very confidently again for the experience of the whole generation about the possibility of constitutional change. But on the other hand, Madison would not be Madison if he didn't want to qualify those remarks, if he didn't want to be more aware of the trade-offs. Or be more open to the kinds of problems, the kinds of difficulties that you would entail. And so another text, which I think you guys will remember fairly well, this is from Federalist 49, which is the first of the two essays, you'll recall, where Madison went out of his way in the Federalist to criticize Thomas Jefferson's proposal for allowing popularly elected conventions to resolve constitutional disputes among the departments, which I think is really a deep, very powerful meditation on the dangers of allowing the people to speak too often or perhaps too loudly in some matters of public affairs. So what does Madison say here? He says, well, the danger of disturbing the public tranquility by interesting too strongly the public passions is a still more serious objection against a frequent reference of constitutional questions to the decision of the whole society. Notwithstanding the success which has attended the revisions of our established forms of government, It was just so much honor to the virtue. Remember, virtue was a key term in 18th century political discourse. It was just so much honor to the virtue and intelligence of the people of America. It must be confessed that the experiments are of too ticklish a nature to be unnecessarily multiplied. And obviously you can tell I love the idea of constitutionalism as a ticklish experiment. Ticklish is a kind of funny adjective to invoke in this context. It's the kind of word we come alive to when we see it. So I thought it would, I put a lot of emphasis in terms of coming up with good titles for my book. So the idea of a book called Ticklish Experiment strikes me as being kind of fun. But of course, the argument can't really inhere in the title. It has to rest on something else. Okay, so this is my point of departure. I mean, if we want to think, as I've tried to do throughout this course, in what I call quasi-crypto proto-Madisonian terms, try to think like a Madisonian, whatever that may mean, thinking about the trade-offs, thinking about what you want to gain on the one hand, but what what the risk you might run. Is a helpful way to frame the problem. It might well be the case. In fact, you can make a perfectly powerful argument. It's a very strong case that however many vices or imperfections we could identify in our existing constitutional system, we don't want to take the risk of putting it all in jeopardy. Or maybe we just have a deep enough commitment to the stability of our regime that the marginal advantages that we might gain in terms of improving the operations of institutions aren't really worth the transaction cost. They aren't really worth the instability you might risk. And also, as many social scientists would say, we always have the doctrine of unintended consequences. We don't fully anticipate what the outcome of events will be. There was a really interesting constitutional experiment that took place in Israel, since the Israelis have their election next week. But I think I can't remember, back in the late 90s or the early part of the aughts, the Israelis went to a system where you could actually vote outright for the premiership, and then go ahead and vote for your slate in the Knesset in the Israeli National Assembly. And what happened was, turned out to be a bad decision, because the appeal of being able to vote for like one of the two or three leading contenders to be premier had the collateral effect of making it easier to vote for the smaller parties. In your second vote, the vote cast not for the main leadership, but just for representation in the Knesset, it had the effect of kind of further multiplying the divisions within the Israeli political system, which went to make coalition politics all the more difficult. It was something, I think some political scientists I've heard from Israeli scholars anticipated this. The lawyers who are involved in this didn't really weigh the political consequences the same way. After a cycle or two, the Israelis abandoned it. Went back to the system they're using this week. But so we never know about unintended consequences. And if you're a historian, which I've been trained to be, worrying about unintended consequences is something historians are supposed to be good at reminding other disciplines of the danger of. So in that case, there is so that's one trade-off of thinking Madisonian terms. Pride in our capacity. We should be able to reason by ourselves on the basis of evidence and through deliberation. We should be able to make improvements, a term they used, improvements in the science of government on the one hand, versus a real concern about transaction costs. Maybe we have an inherent stake in stability that we don't want to jeopardize. That's trade-off number one. The second trade-off I just want to mention briefly, and actually I have a little illustration for this. So somewhere, I think out of the audience, is a good friend of mine, a guy named Sandy Levinson, who teaches law at the University of Texas and is a major recurring critic of the Constitution. In this book, Our Undemocratic Constitution, you might notice it goes very well with my tie. We have the standard, standard illustration here. So Sandy's a strong critic of all the multiple decision points that our Constitution creates, and therefore all the barriers our Constitution creates to having efficacious political action. And he attributes a lot of the force of this to the Constitution itself, to that 18th century notion of divided government, balanced government, separation of powers, checks and balances, and so on. He may be right, may be wrong. I happen to think, and this is a kind of Madisonian exercise, that the boundary between how many of our problems are determined by the structure of the Constitution versus how many of them are determined by the character of our politics, that's a very tricky enterprise. How much this really reflects the constitutional structure within which we operate, the design of the institutions, the design of the electoral system on the one hand, versus what are the political passions, or what I call on the outline, the life force, or in Madisonian language, the interests, passions, and opinions that are coursing through the body politic. That's a real kind of tough exercise. And if you think back to Federalist 37, that essay we also paid some attention to at the start of the course, where Madison tries to, forces us to ask, what are the difficulties of reasoning about political phenomena? Where do you draw the boundary between what's constitutional and what's political? where these areas are permeable. So you can't really be sure, is it a constitutional source or a political source that's the source of your problem? That's another issue I think we have to keep in mind. Okay, so those are kind of two background Madisonian observations here. In the balance of time remaining, I want to spend some time talking about, in my short list of Rakovian vices, I really want to talk about three issues. I'll say up front what they are, time permitting. It's unlikely at the end of the course, but you never know. I might try to squeeze in one or two others by way of commentary at the end. But the three I want to talk about, I want to talk first about the Senate filibuster and why I consider that so deeply problematic in a fundamental constitutional sense. I want to talk about the Electoral College, which we spent a little time talking about on Monday when we discussed Bush v. Gore, but I want to come back and raise some issues about how that system works. And I want to say something more about judicial appointments, which we also discussed briefly on Monday, and I want to come back and try to say a bit more about this morning. So those are the three examples of Rakovian vices juxtaposed to Madisonian vices that I want to discuss this morning. I see it's only about 10:15, so I feel I'm actually somewhat out of habit. I'm actually in fairly good position to try to get through most of these. From this point on, the illustrations are all just meant as visual diversions. It won't have any substantive value. This, of course, is a famous slide from what great movie? Mr. Smith Goes to Washington. I think the last time I saw it was at the Stanford Theater with Jimmy Stewart, who really, I think one of the great figures in American film history, a real hero. I mean, if you know anything about his war service, unlike a lot of other poseurs during World War II, he was the real thing. He was a bomber pilot, became a wing commander. He wasn't just a handsome guy with a genial manner that he displayed on the stage. So this, of course, is the famous scene where Jimmy Stewart, I forgot what the name of his character is in the movie, but where he's staging his famous filibuster. I think this is the scene where he gets all the kind of letters that have been mailed in by the machine bosses. I always thought it was probably Missouri. I can't remember what it was. Missouri's come from, whatever, someplace out of the Midwest, which the machine has kind of been cranking in to try to undercut his position. So this is the classic depiction of a filibuster. Okay. So let's talk about the filibuster. I may oversimplify a bit. It may be that the filibuster in the modern closure rules, the idea that in order to close debate in the Senate, you need to have 60 votes. So in effect, it used to be 2/3 when the filibuster was primarily designed to protect the South, or was primarily used to protect the South against anything smacking of civil rights legislation. You might remember we talked briefly about the Civil Rights Acts of 1957 and 1960, which wound up being too trivial that one commentator noted they weren't even worth the filibuster because they weren't going to do anything significant that would really affect the South's dominance. So my opening proposition here is that the closer the deliberation rules of the Senate come to a rule of decision, the more the American people are deprived of their fundamental right to be governed by majority rule. So that's the basic argument I want to make. So I want to try to distinguish two modes of senatorial procedure. One is we want to have rules of debate, and the other is we want to have rules of decision. So one is under what kind of procedures should the Senate be allowed to act the role it's supposed to act. The role Madison actually talks about very positively in Federalist 62 and 63, to serve as a restraint on impulsive legislation or legislation that's being formed too hastily or too impulsively in the lower house. So we have rules of deliberation. We also have rules of decision. The basic argument I want to make is if the rules of deliberation and the rule of decision converge, so that the distinction between them is virtually evaporated. 40 senators, if they choose to do so, can effectively block decisions on any matter of state. A minority can outweigh a majority. If the distinction between a rule of deliberation, rule of decision has evaporated, we as American citizens, or the American body politic, the people of the United States, we the people, as noted on the tie, are being deprived of what should be a fundamental right of majority government, which is to be governed by, a fundamental right of Republican government, which is to be governed by majority rule. You guys with me on this? Okay. So here's the argument I want to make. First off, I have to concede at the outset, this is not an issue one could ever litigate. Each house of Congress has constitutional authority to make its own rules of proceedings. So if the convention, if in one sense one chamber feels we want to allow unended debate to go on, This is really, it's really a decision that's I would say it's non-justiciable. You know, it would fall pretty readily under the political question doctrine, an area where the courts just can't intervene. I mean, you know, on what basis could the Judiciary Department tell, you know, another institution, this is how I think you ought to conduct your deliberations? I mean, that seems to be a fairly straightforward position. So if we want to think about constitutionalism in a highly legalized sense, could you sue to kind of overcome this barrier? That's kind of a non-starter. That falls into the famous niche category of analysis, which I hope you guys have come to incorporate over the course of the term. So you can't litigate it, but I also happen to think it remains unconstitutional. Not just problematic, I would want to argue it remains unconstitutional in a basic normative sense. Maybe not in a legal sense, not something you could, you know, bring to court. You couldn't get an injunction to force a vote. But I happen to think that on the merits, if we think constitutionally, not simply in terms of litigation, but in terms of what are the values, you know, what norms should the Constitution, under what norms should the Constitution be operating, I happen to think it's unconstitutional. And I'll start with a kind of textual argument about this. I think I used this once before, and Habib, I think you can probably do the translation because this one's fairly straightforward. So there is a well-known rule of legal interpretation. So actually, this is a legalistic argument, but I think it relates to the Constitution as, you know, as a written document, which says expressio unius est exclusio alterius.
The expression of one is the exclusion of the other.
Right. So this actually, almost everybody, not just anybody should be able to translate this basically. The expression of one is the exclusion of the other. If you have a legal document which explicitly identifies cases where supermajorities apply, by default, what's not expressed has to fall under some other rule. So there are 4 cases where the Constitution does require supermajorities. I hope get these all right. But ratification of treaties, of course, you can think about that in terms of our current Iran debate. The approval of constitutional amendments, overriding the veto, the presidential veto, and anybody remember the 4th case? Relating to the Senate? Impeachment. Very good. Yeah. So it last figured in, what, 1998, 1999. 1999 was when the impeachment trial, Bill Clinton, actually took place. So I think this is actually a pretty powerful rule. The framers of the Constitution were very self-conscious. The existence of the rule is a well-known canon of construction. B, they did spend a lot of time thinking about when supermajorities were and were not necessary. A good example of this is that, well, there was a lot of discussion about how big a veto would you want to have. Madison actually wanted to, I think, raise the I think Madison at one point proposes having a 7/8 supermajority to override a veto, which is a bit on the high side. You know, go from 0.67 to what, 0.875. That's a non-trivial increment. There was a lot of debate. It comes actually from George Mason of Virginia, arguing that to protect the regional interests of the South, you ought to have 2/3 majorities for what were called navigation acts, or what we would call, you know, uses of the Commerce Clause. So the framers, there's some other examples, I think, where supermajorities were discussed. So at the outset, I would want to say that, you know, in normative terms, if not in justiciable terms, there was something that's deeply problematic about the idea of, in effect, having a 3/5 rule for legislation to be effective. Different way to think about this. I didn't put this on the outline, but it's worth discussing. If you just think about the composition of the Senate. So, as you guys well know, I would abolish equal state vote in the Senate tomorrow. I think it's outrageous. I think it's wholly unwarranted. I don't think citizens in small states have interests that are different from citizens in large states. If the Second Amendment's your big issue, it doesn't matter whether you live in Michigan or Wyoming. If you're deeply evangelical, that defines your politics. Doesn't matter whether you live, you know, in Texas or in, you know, whatever, Idaho. You know, or usually Wyoming is my favorite example here for small states. So, you know, in that sense, you know, I find the whole notion kind of problematic. But what's interesting is when the framers of the Constitution adopted what I think was mistakenly called the Great Compromise or the Connecticut Compromise. That was, as far as many of them felt one should go, to protect minority interests. In other words, people like Madison, James Wilson, Rufus King, Governor Morris, Alexander Hamilton, people were strong advocates of having some rule of proportionality applied to both houses of Congress, argued, they reluctantly accept what was actually a very narrow decision within the convention to give the states an equal vote. They felt that went far enough to say that instead of going far enough, that's just the foundation for introducing other minoritarian checks on majority rule would strike them as being outrageous. In other words, you're making one exception, but that exception should by itself have been sufficient. You should not have needed to say, okay, here's one basis. Now let's think of all the different ways in which we can compound that. So I think there's another normative level, kind of deeply principled level, at which this is this is deeply problematic. Okay, so that's my argument. So in a sense, if you think constitutionally, juxtapose the political questions doctrine, which I think makes it non-justiciable, with, however, I think a normative claim based on essential principles of constitutional rule. I think you would come out saying that in fact there is something truly problematic. I would say unconstitutional about a procedure where if the rule of deliberation and the rule of decision, they have effectively converged. So that it's very hard to distinguish one from the other. I'm not saying the Senate should have the same rules of deliberation as the House. That would be, it seems to me, that would be improper and would kind of undermine its basic purpose. But it's not really a rule of deliberation to say we're not going to vote. That's essentially a rule of obstruction. Rule of deliberations are meant to improve deliberation. Once deliberation is ceased, you want to get a decision one way or the other. And the procedure rule should not be the default barrier to an actual deliberative decision taken on the merits. Okay. Now, but let's go back to what I tried to say earlier. When we think about this in, as I said, my second part of the Madison dilemma is how do we juxtapose constitutional concerns with political concerns, right? So try to work that out. So this is an interesting question. So it doesn't bother me, particularly after this goofy letter from 47 Republican senators, which really is a constitutional novelty of the first order of magnitude. Anyhow, putting that little quibble aside, it doesn't bother me at the moment that there are more than 40 Democratic senators, and that I think Republican action, both in terms of receiving Bibi Netanyahu and then with this recent letter, are more likely to ratchet up Democratic loyalty to Obama than to work the other way. So it doesn't bother me politically that at the moment, in the current set of circumstances, it's hard to see how the Republicans would ever get 60 votes or 67 votes in terms of veto override, because they've kind of gone out of their way to offend the Democrats, as best they could. So it might well be that if we just want to reason expedient grounds, whatever I say in principle, when push comes to shove or as a matter of implementation, and remember my general argument that most of our constitutional arguments are inherently instrumental in nature. It's hard for us to adopt abstract positions. What we really prefer are in any given controversy or the outcomes. We prefer mechanisms of constitutional decision-making that are most likely to produce the outcomes that we individually prefer. So, maybe I should just remain a Cook County Democrat and say, actually, the 60, the Democrats have more than 40, and I'm a Cook County Democrat by birth. Maybe this is not such a bad rule. But I don't really want to follow that logic, because I think what I really want to say is the corresponding point here is, I think a better system is we want to be, we are a democracy. We want to be governed by democratic principles. To be a member of democracy, we protect minority rights in lots of ways, particularly, through a bold protection of civil rights, which is why I like the Warren Court so much, by in terms of its pursuing the incorporation doctrine fairly rigorously. But in the end, it seems to me we want to be governed by a system of elections. We want to be popular constitutionalists in the same way that Larry Kramer would use that term. Namely, if we have constitutional disputes or if we have big political disputes that have constitutional implications, in the end, it seems to me elections rather than rules ought to govern. So we ought to allow majorities to govern. I mean, it's hard enough to form a majority in any case in the American system. We want to have majorities govern, and then we can deal with the consequences. As opposed to having a system where we're doing our best to paralyze the capacity of majorities to govern, don't we want to encourage action and then try to make sense of what's been done? Now, Cameron may not like this position because it's anti-libertarian, right? I mean, I'm saying I want government to act. That's my expectation. That's why we created the damn thing. It wasn't for inaction, it was for action. And elections have consequences. I should say decisions have consequences, and that's what elections should be designed to measure. So that's my argument about the Senate. I'd also got rid of an equal state vote, but as you remember, from the great opening line. You can always use it in a mixer. What's the only clause of the Constitution not subject to Article 5 amendment? No state can Habib.
States can have their equal representation taken away from them.
Right. No state can be deprived of its equal vote in the Senate without its consent. So that deals with. Let's check the time here. 10:30. This is good. I'm actually on schedule, more or less. Flew Zoom one. This will be a real This isn't be a big revelation in podcast land if they have the bitter experience of my trying to finish the lecture. Lily, you want to say something? You got to.
So I've just been wondering for a couple lectures what the normative value of the political question doctrine is. Like,
right.
It seems really obvious that there's just no incentives for the legislative branches to check themselves, but there's huge constitutional consequences. So wouldn't a third party have to step in?
Yeah.
For anything
Right.
to change? So I just don't understand why defaulting to the political question doctrine makes sense.
I think someone said it comes. Okay, so Lily, who's my TA, has just been asking. She's having problems grappling with the significance of the political question doctrine, which is the basis on which courts, if they want to stay away from something, can do so. Let's see. I'm going to sit on that one for now, but it's a good question. I may get, with a little bit of luck and favor from the powers above, I might be able to reach it, towards the end. Okay, I can tell you're looking a little, perturbed there. Okay, second proposition. The persistence of a state-based system for presidential elections not only violates the basic principle of one person, one vote, it also leads to the delegitimation. I think that's the proper word. To the delegitimation or delegitimization, I like, of presidential power. So this picks up a bit on our discussion from Monday about Bush v. Gore and the 2000 election. So the slide here, obviously, this is, of course, what we really know about Obama, beyond the fact that he's a Kenyan anti-colonialist and all, whatever, is that even though he taught constitutional law in my birthplace, the University of Chicago, his whole purpose in life is to tear up the Constitution. It's really the secret mission he's been pursuing, and we have to deal with the consequences. This slide, and you can find lots more like this, and many of a much viler character, all protected by the First Amendment. Kind of deal. This comes from Patriot Post US. I have no idea what this website is. That's down at the very bottom of the slide. Anyhow, so let's talk a bit about the Electoral College, something I've been agonizing a lot since the 2000 election. I explained on Monday, when we talked about Bush v. Gore, that my original source of concern, some of it had to do with the idea of why should we have a winner-take-all rule for the states of 6 million voters in the state of Florida? Were maybe 1,000 votes apart, depending on how you treat the West Palm Beach vote and the Jacksonville vote and so on. Isn't there something kind of silly about having a winner-take-all rule that goes to a nominal majority? But there's a certain logic that kind of electoral college had. Anyhow, for a long time I've had a kind of concern with the federal problem of the way in which the construction of electoral college violates the what I think has become, ever since Baker versus Carr, ever since the great reapportionment decisions, which were a case when putting the political questions doctrine aside wound up, I think, A, to be proper, and B, to work very well. My original concern had to do, though, with the way in which, because of the so-called senatorial bump, the value of an individual vote varies from state to state. Now, of course, you have to work out to many decimal points what that really means. And I don't know if you should feel it personally, when you go home after casting your ballot. But it is true that votes have very different weights, and the senatorial bump, is a significant way of ratcheting up the vote. If you look at the 2000 election, as I noted, there were 51 electoral units. Gore carried, I think, 21 for 267 electoral votes. So basically, if I do the arithmetic, about 13 votes a pop, per electoral unit, per state or D.C. Bush carried 30 for 270, 271, 9 votes a pop. Bush carries the 20 smallest units 13-7, and the electoral margin was between them was 4 votes coming out, and then one D.C. elector threw her vote away. So you might say, if you want to talk about the various injustices of the 2000 election, that the simple construction of the Electoral College was an obvious factor there. It's a pretty straightforward argument. I don't. It's not the one I really wanted to belabor. I've got much more interested, I think, really watching the Obama presidency. And I'm a much bigger fan of Obama now than I was, I think, when he took office, for reasons I won't get into. But there are some things I really like about how he's conducted himself. I've started worrying a lot about what seems to me is a kind of disturbing tendency in American politics, which is the extent to which People might grab the door, which is the extent to which the last three presidencies have been marked, I think, by a concerted delegitimation of the nature of the presidency. And I'll say something about this in a minute. So let's just start with a couple starting points here. So one starting position I'd have as a basic matter of democratic theory is we have only one truly national political office, right? That is the presidency. It's well, depending on how you think about the vice president, but that's just ever since 1800 that issue hasn't been all that important. It seems to me if it is a truly national office, then to follow the one vote, one person rule out to its logical conclusion, all votes should count equally. A vote cast in California should have the same value as a vote cast in Wyoming, just as a fundamental democratic value. Votes in one state should not count for more, even if we have to multiply out to X number of decimal places, based on the accident geography. So that's that's a kind of starting position based on equal protection. I don't think that really needs much defense. I think that one's fairly straightforward. What I think is more important, and actually a point I didn't really put in here, but let me stress now is, next point is, if we think about the nature of presidential elections, I think this has become more and more clear with each passing election. I mentioned the other day that Richard Nixon back in 1960 did this crazy thing of he vowed to campaign in all 50 states. He banged up his knee. He lost 2 or 3 weeks of the campaign because he had an infection and he was had to recover. He should have at that point he should have forfeited the promise. He didn't have to go to all 50 states. He would have known which states he was certainly going to carry. And which ones not. So Nixon kind of doing so that way. But our ability to predict how states vote now is vastly more sophisticated, because of the increasing refinement of polling techniques than it would have been, 50 some years ago. 54, 55 years ago. So now we have this interesting map. We know as a matter of course, that the preponderance of states, what are the red states and what are the blue states, and then we identify the battleground states. And, they can be a relatively small number, it can be a relatively large number. There's nothing special about being in a battleground state. Battleground states are not different. Their voters do not have preferences that are different from the voters in other states. I mean, they'll have somewhat different preferences based on the composition of their population. But it's not that there's anything special about them in states, except that the political forces within them are in relatively equal balance. As to say, if you think that demography, which I think is true in my capacity as a political scientist, if you think that demography, that's our various social characteristics, religion, ethnicity, occupation, education, and so on. If those are the real determinants of political behavior, what happens in battleground states is that just the distribution works out so that those states turn out to be competitive. The result of this is we have this kind of crazy presidential elections. We all care passionately about the outcome. We're all deeply interested in it. But the reality of presidential elections is if you live in a battleground state, it must actually be an awful experience. How would I know? I've lived in California the last 5 years. But in presidential elections, to be subjected to all those advertisements, hour to hour, day in, day out, whereas the rest of us, have to read the newspaper to know that there's a political campaign's going on. So I think you might say in terms of fostering democratic culture, there is something fundamentally wrong, or skewed, might be a better way to put it, about the way in which our ability to measure the political loyalty of states so refined a way really operates. So you might say that derogates from the character of the election. But I think, having made that point, which I think is now a fairly obvious one, let me make 2 additional points to develop this. The first thing that I see the real advantage of having, if you had a national popular election, there would be one constituency. Let's think of a name. I don't know. Well, we call it the United States of America, right? There would be one constituency. You would not vote as a member of a state. A vote would count the same wherever it was. In response to the current problem we have, which is states have the incentive to turn out their voters only in battleground states, I happen to think that the parties have an incentive to turn out their voters only in competitive states, only in battleground states. I happen to think that the parties would discover a strong incentive to turn out their voters everywhere. It's not just the candidates would spend all their time in New York and L.A. or the Bay Area or Chicago. and leave the rest of the country aside. It's a big country. There are lots of voters out there. And if a vote is a vote is a vote, wherever it is cast, all votes count equally, the parties would develop technologies, mechanisms to turn out their vote everywhere. Now, there'd be different strategies. I have no idea how this would affect media buys. That's a complicated question, is where you invest your resources. But if a vote is a vote is a vote, and if you think, if you're moving towards a competitive election, which, it's not clear how competitive Republicans can be with Democrats anymore, but Republicans would probably actually do better in the national political election because they may come up with candidates who are more attractive nationally than their party strength and the electoral map. Republicans have a real struggle now to get to 270. They really have to go uphill to try to get a presidential majority. That's been fairly clear from the last few elections, I think. So I think A, we'd incentivize, but B, the issue that really concerns me more, which I think goes to the nature of our constitutional system, so it seems to me, as I reflect on the last three presidencies, Obama, here, happily tearing up the Constitution, Bush, who comes to office under the cloud of Bush v. Gore, having lost a popular vote, and then Bill Clinton, who was Bill Clinton, and attracted it was kind of the Slick Willie thing, and I think the fact that Republicans are really peeved because they thought or worried that Ross Perot, the third-party candidate from Texas, whose prosperity basically depended on getting contracts with the government. It wasn't as if he was the greatest entrepreneur out there in the world. Anyhow, I think Republicans felt that they had a right to the presidency, which had somehow been denied by Ross Perot, and they wound up with, Slick Willie, this kind of wily, highly charged candidate from Arkansas or Arkansas or whatever. It seems to me if you reflect on the last three presidencies, and if you think about the way in which the idea that the country is divided into red and blue states with a handful of oddball battleground states, it seems to me in some sense that has been derogatory. It's been, it has disparaged the authority of the presidency. There are different explanations. I think in Obama's case, to be honest, I think, I won't say raw racism, but a kind of strong latent racism. Sometimes bursting into, raw racism in some moments. I think that's certainly been a factor here. I happen to think, just throw this out as a hypothesis. I've thought a lot about the one person, one vote issue ever since 2000. But now I think actually there's a deeper argument to be made, which is that the presidency is the linchpin of decision-making in our government. To have a system where the election was truly national, where it's not imagined as a set of red states versus blue states, with the battleground states, hanging in the balance. I think that would be healthy for us. I think it would promote the political health of the presidency. I think it would, you see, we all have the same First Amendment rights, so we all be free, we'll all be free to, to attack presidents on whatever grounds you do. But I think actually shifting the basis of election, in addition to solving the one person, one vote problem, which I think is, is a fundamental democratic issue, would also have that advantage. So that's an argument about how much you guys think about it. I think this is an issue that's going to recur. The third point I want to make, and we kind of picked up a bit on this on Monday as well. When I should tell the podcast audience, or whatever, the title of Monday's lecture was, "It's Constitutional Law a Farce?" For which Bush v. Gore stood as the leading example. So just picking up on that, I'm deeply disturbed, I think many of us are, about the whole nature of the judicial appointments process. 7 minutes. We had a bit of a debate, discussion a week or two ago. When exactly did it begin? Some people argue that the nomination of Robert Bork, and then, which led eventually to the nomination and appointment of Anthony Kennedy, was the true point of departure. I'm not so sure about that. I think it went back to 1969, and look at the way in which Gerald Ford led the effort to prevent Abe Fortas from succeeding Earl Ward. And then if you look at the controversy over Richard Nixon's Southern appointments, the Haynesworth to Carswell to Lewis Powell trilogy that wound up with Lewis Powell being appointed, it could be, as I tried to suggest the other day, that the appointment system which we now operate makes independent tenure the dominant variable, and the independent variable, and the real dependent variable, arguably, or as the lawyers say, arguendo, is actually the political dependence of the judiciary. Now, it's not perfect. You can make mistakes. You could appoint David Souter without realizing he was a liberal, so that's a tribute to John Sununu's political genius as a New Hampshire Republican. Justice Stevens, appointed by Gerald Ford, I think was your kind of classic Republican moderate. And Ford was not a strong ideologue. So he didn't really, he didn't really have a dog in that fight. So okay, it's not that every appointment works out exactly as you wished it would, but I think it's fairly evident if you look at the current court. Now we need another slide up here. Here's our current court. I actually find the photography here. Make sure you get this. This was, I mean, I'm a little nervous about the body language of the four conservatives. I mean, Alito looks okay in the back, but there's something. I mean, Thomas looks angry. Scalia looks distracted. Roberts is glancing aside, and Kennedy's off in his own little world. And I'm not quite sure. Of course, it's just random photography, right? It probably doesn't mean anything, but it's kind of fun to look at. Of course, you realize how petite Justice Ginsburg, who's my class is going to visit. Either she's going to visit us or we're going to see her in her chambers. I think on May the 3rd, the first Tuesday in May. My class next quarter in Washington is going to have a little visit with Justice Ginsburg. The people standing up look a lot happier. 3 liberals and Alito, who I describe on the outline North as a shapeshifter. So, maybe this is Alito doing a bit of shapeshifting, trying to appear like a nice guy. So anyhow, so here's our current court. So as I said the other day, it's not that every decision is 5-4 in a predictable way. And I think the King versus Burwell decision is going to be really interesting. I'm predicting 6-3 with Roberts and Kennedy voting with the liberals, but historians should never predict anything, so my predictions are wholly meaningless and probably wrong. But I have started, as I say here, the judicial appointments process now operates to produce politically reliable judges, turning jurisprudence into a continuation of politics by other means. That's a play on the famous statement by Karl von Clausewitz, the great Prussian military strategist, that war is a continuation of politics or policy by other means. And it doesn't work perfectly, but it works well enough that we ought to be disturbed by it. So my alternative proposal is, why not limit, I don't care about federal judges. I mean, I think life tenure for federal judges is fine. But maybe more rotation on the Supreme Court, the ultimate decision maker, would not be a bad idea. So I kind of like the idea of having 18-year terms or 22-year terms. There's a bit of numerology going on here. Anybody guess why I would like 18? Alex, do you know this one? No, it has nothing to do with multiples.
It's the 18th letter of the.
No. It has to do with Hebrew numerology. It has to do with the idea of gematria. That in Hebrew letters have numerical values. Chai, Chet Yud is the word life. I'm sorry, you're about to say that? I'm sorry, Allison. So that's why we often give prizes in multiples of 18. It's a little bit of a superstition. That's 18. Habib, do you remember why I like 22?
Oh, is that the number that you dropped on Stanford D?
No, it's the number. That's the number of points I got against Aberdeen in the second round of the Scottish Cup when I was an All-Scottish Universities basketball player in 1967. I got 22 against Aberdeen. So these are two numbers to which I'm personally, if it was Sesame Street, these would be my favorite numbers. If I were Kermit the Frog. So I like 18. I like 22. That's a long period. No, 18 years. That's a lot of years. 22 years ago, I was still playing basketball, something I haven't done since 1994. So that's not, these are not bad numbers. I've started to think that, in part, maybe having terms. I mean, I ask the question, why should justices, it doesn't work in every case. Sometimes you die in office. But justices have the option of deciding when they're going to retire, and they can do that on the basis, in terms of political preferences. Been a lot of speculation about Justice Ginsburg, who actually, according to my student who's clerking for now, she's actually tough as nails. Her physical trainer is quite impressed with her workouts. She looks petite, but she can do push-ups and the like. And her jurisprudence is, from my point of view, is fabulous. So I think she should stay in the court. But whether we're well served by having a court of this nature, when it seems to me you can make such a strong argument that political preferences are the dominant variable driving judicial behavior, to me, is a really interesting question. It's also worth noting, one of the, I think, actually, Amy, I think it was your mom who sent in a question on this, having to do, I'll have to answer privately, but, Citizens United. One of the interesting things about the court, if you read the recent books about the court, Marcia Coyle's book and I think Jeff Toobin's book on the Roberts Court, it's clear that much of the agenda of the current court since the middle of the last decade has been driven by Alito's appointment. So Alito, who's a dyed-in-the-wool conservative, as is Thomas, as is Scalia. And these guys appear in Federal Society regularly and so on and so on. It's clear that the replacement of a true swing voter, Sandra Day O'Connor, the last person on the court to have any elective experience in a political office, it's clear that Alito's presence shifted the margins, and the justices knew it. I mean, a lot of the litigation driving the erosion of any kind of contribution barriers in the realm of campaign finance. It's clearly driven by Alito's presence. So that means actually, and the court signals this. I mean, the court kind of invites, not bring me your poor, your huddled masses, bring me some contrived case because I'm ready to rule on it in a way that's going to alter the jurisprudence. So, you have to ask a question. This is not, I mean, we talked a lot in the class about it is important in the American system to understand how ordinary cases can develop into constitutional issues. And that's fine. But when it's being driven in this way, when these are the parameters of how these discussions evolve, that I think should be disturbing. And I think Justice Alito, I don't think he's actually a shapeshifter in his private life, whatever that means, but it's clear that his appointment, that the changing political balance on the court was what has shifted its jurisprudence. And finally, the last point, and this one is made by, recently by a well-known political theorist, and I'm going to try to wrap this up in about next 90 seconds, so just sit still. Finally, there's a kind of much deeper theoretical question. A guy named Jeremy Waldron, who's been writing a lot as a great judicial review, raises a really interesting argument, saying that it might well be the case that you need strong constitutional courts in emerging democracies, right? You need to have an institution with independent authority that's capable of ruling on a whole array of issues as part of a process of transition, so that whoever occupies power first will not use that original position to corrupt advantage. So having a strong constitutional court to enforce constitutional norms in order to build up mechanisms of democratic continuity, maybe that's really valuable. But we've been around as a constitutional republic for a quarter, not quite a quarter millennium, but we're getting in striking distance of that. We're actually 2.25, 225 years, give or take, as of this year. This is putting the Civil War aside, another one of my little quibbles. This is a strongly established constitutional democracy. Why do we think that the court is better qualified to resolve fundamental questions of policy? If you think about the Obamacare litigation, think about that in the light of Wickard versus Filburn, the famous New Deal case, or how you measure the commercial nexus. It's a real troubling question. But do we really need a court as strong or as assertive as the one we have now is? What value is it pursuing, again, if we make those political assumptions? So I'm going to wrap it up. So I'll just say I'll just make two last points here. Each of the points I've raised seems to me to represent a strong democratic value. So a rethinking of these issues would force us, I think, to think in more robust terms about what is the nature of the constitutional democracy, not so much a republic anymore. What is the nature of the constitutional democracy that we want to have? That's point number one. Point number two, go back to my original quotations from Madison. Is there not something absurd about saying that just because Article 5 is difficult or it creates high hurdles, we should never talk about constitutional change again? Shouldn't we go back to the opening paragraph of Federalist 1 or Madison's sentiments in Federalist 14 and say, we are capable of reasoning about the nature of political phenomena. We have a political system which is deteriorating into a mess for a variety of reasons. Should we not be able to think rationally through some processes of collective deliberation about what a different system should look like? So that's my course, and we'll see you guys on the final. And goodbye to those of you in podcast land or whatever. I hope you found the last 50 minutes enjoyable. Thanks a lot. Thanks, guys.